So much for watching Law School Made Easy at Law School Made Easy 256. Today we want to straight go to contract law, and we want to dissect how to answer contract law when you are faced with most of these questions in contract law 2. Of course, this semester we are looking at the vitiating factors. So we are going to discuss what the lecturers expect, where are you supposed to put your energies as you're reading, and then so that you can appreciate all these concepts. We want to thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. If you want to become a member of this channel, you just press the join button, and then they will charge you 5,000 shillings for a month. You become a member, you're the first person to get the visit. There are those other benefits, incentives of being a member of this channel, Law School Made Easy. So click the join button, and thereafter insert in your ATM card. They will charge you 5,000 shillings if you have an ATM card, and then you will be getting videos. You're the first person to get the video every other time we come. Then to other colleagues, please subscribe. Hit the notification button such that every time we upload a video, you get a notification that there is a new video. And now let's go straight to contract law. We begin with misrepresentation. Colleagues, when discussing misrepresentation, be mindful of the sections of the Act that define misrepresentation. Be mindful of the principles that govern misrepresentation. Among them, we have statements of fact. Remember, this is when someone induces the other to enter into a contract. So we are saying the key areas for us to appreciate is concepts of fact, and so the statement of fact and statements of opinion. We must differentiate what is statement of opinion, what is statement of fact, what amounts to a statement of opinion. So if somebody says in your problem question they have set for you statements of opinion, this means that someone cannot be held liable if because of their statement of opinion. You have a case of Bissett versus Wilkinson, that case of the court. Please address your minds to that case. It's locus classicus for statements of opinion, because even court ruled and said in that case that Mr. Wilkinson, the plaintiff in this case did not rear goats before, sheep before, so there is no way he would ascertain a number of sheep to be reared. So it was just a statement of opinion which cannot amount to misrepresentation. Then look at statements of fact. Statements of fact, that some statements of fact amount to misrepresentation. Differentiate between the two, and then you go. Then on the definition, you have that case of Ademusana versus Kanguma. It's a very locus classicus case. Look at it, defined misrepresentation. Then let us look at change of circumstance. These are some of the concepts where they want to examine a change of circumstance, that it is the duty of the representer, if there is any change of circumstance, to inform the representee that, look here, things have changed. Look at that case of the doctors with versus of Flanagan. It's a locus classicus, that because things had changed, it was now upon the the defendant in that case, or the representer who initiated the program, to communicate to the representee that, look here guys, the circumstance, things have changed. As you come to do this, things have changed. So that part is very examinable. Then look at the part of silence does not amount to misrepresentation. Clause 2, subsection 2 of section 14 of the Contracts Act. That silence does not amount to misrepresentation. But where it is the duty of someone keeping quiet to speak, it will amount. Take note. And then, if silence in itself is equivalent to speech. So, colleagues, you understand that now silence does not amount to misrepresentation. but there are exceptions, okay, where silence will amount to misrepresentation. One of them is if it is the duty of somebody keeping quiet to speak. That's one of the exceptions. And then another one is if silence itself is equivalent to speech. And then another exception is half-truth. Look at the case of Demok versus Haaland, where he never talked that the tenants were leaving. He just said their rooms are all occupied, but he hid some of the facts. So in that way, silence will amount to misrepresentation. Look at contractors who be mere fidel, utmost truth, where you are under duty to speak the truth and you don't disclose everything, then silence will amount to misrepresentation. And that's an examinable area. And then let us look at the types of misrepresentation. Among them we have fraudulent misrepresentation, we have negligent misrepresentation, and then we have innocent misrepresentation. Now, when you look at fraudulent, colleagues, do not go answer that number if you do not know the facts of daily versus peak, because that is locus classicus. And then the definition of fraudulent, we get it from the case of daily peak. So read and appreciate the concept, how we arrive at that definition of fraudulent misrepresentation, which says when somebody does something knowingly, recklessly, scared, without believing in what they are saying, that is what amounts to misrepresentation. So fraudulent, and then colleagues, very important is what they call if they ask you in the question and they put, for example, any case, say daily peak, if you don't know the facts of the case in that question, whether short notice, do not answer. Because it's very important for you to appreciate and know the facts of the case. Then negligent, this is about fiduciary relationship, Elderbrain versus Heller. Locus classicus, look at it, appreciate fiduciary, that you are under duty to advise. Fiduciary could mean lawyer and client, doctor and patient, accountant, the insurance guys and the clients. So you, the advocate, the lawyer, you are under duty to explain, to teach, or to tell the client, to advise them well. So in the event you don't advise them, then you have misrepresented and you'll be held liable. Let's now go to mistake. Colleagues, mistake. Mistake as a topic, there are three types of mistake. We must agree. But keynotes to see all the types of mistake. What do they lead us to? It's very important. Sorry, in misrepresentation, the misrepresentation makes a contract voidable. That a contract now is at the will of the plaintiff, either to rescind the contract, to repudiate it, or to continue with it. So it makes a contract voidable. Then mistake makes a contract void. So it's important to know, and you talk about it, what is the effect of a mistake, what is the effect of misrepresentation on a contract. Then you look at those areas, the types of mistake, the common mistake, the mutual mistake, and the unilateral. So under common, clearly explain res extincta and res sua, and have cases in there. Res extincta and res sua. And then common mutual mistake, when all the parties are operating under mistake. We have Ralph versus which Hallas, that boat, the ship, sorry. And then when you go to unilateral, now this is where we want to examine unilateral. Under unilateral, there is that one party knows that we are operating, but one party knows that this person is doing a mistake, but for them they keep quiet, they conceal, they keep quiet about the truth and they continue. That is now fraud. So they will tell you question, somebody came and pretended to be so and so, a professor, he did this, all those things. They want you to discuss unilateral mistake. But again, there is the concept of nemo dat quod non habet, the maxim of nemo dat quod non habet. You cannot pass on the title you do not have. So meaning that when somebody masquerades or pretends under unilateral mistake, then somebody masquerades and then pretends to be who they are not. In case, or when somebody steals somebody's property, they cannot sell that property, or they cannot pass on a title that is better than the one they have. You can't transfer. For example, let me explain the concept of nemo dat quod non habet. It means that, for example, if I go myself and I steal Eunice's phone. Now, if I steal Eunice's phone and then I get the phone, I want to sell it to Alvin. So if I sell the phone to Alvin and excuse me, and Eunice finds the phone with Alvin, Eunice can claim their phone and take it from Alvin. Alvin cannot say I bought it. Yes, Alvin bought the phone to me, but me, I stole the phone. So I cannot pass on the title. I can't pass on the title to Alvin. So when they find him, they will take it. So that's the whole concept. They know I want to examine you about the concept of nemo dat quod non habet. And then under there still there is a non est factum. Please read about when is it applied, that defense non est factum, which means it's not my deed. Look at the case of Saunders versus Angalia Building Society. Lucas Clascas, or discussing non-esteem factum or documents which are mistakenly signed. If you sign a document, so you can plead the defense of non-est factum, that it is not my deed. What you're claiming to be mine is not my deed. I did not sign. Look at the case of Saunders versus Angalia Building Society, and then look at the exceptions when that defense may not stand or when it can't stand. So let's cross to discharge of an agreement. Colleagues, under discharge of an agreement, we have 4 elements. We can discharge a contract by performance, by agreement, by breach, and by frustration. But I want to urge colleagues, as we read all of them, let's focus on frustration and then performance. Look at first the general rule at common law under performance. Performance was to be precise and exact. So following that, look at performance. What are those remedies under performance which were created? Substantial performance, partial performance. Look at the principles of when somebody performs part duty, then we shall pay them for what they have performed, and very many others. So look at the concept of performance and appreciate it, and then you cross the concept of frustration. That when is the contract frustrated? Now, under frustration, presence availability of the subject matter or non-existent of the subject matter. Look at the case of Cardwell, look at Cascas there, and then appreciate and understand the concept of frustration. And then, of course, need to understand discharge by agreement. Look at code and satisfaction, which is purchase release. Look at the waivers. Look at the novation. Under novation, we argue to substitute the original with the new contract. Under waiver, you want to waive somebody of their duty under the original contract. And then accord is agreement. You agree to the new price. That, okay, you're supposed to pay my money on accord and satisfaction. So you're supposed to pay my money on the 18th. You don't have the money, okay, you now pay on the 20th. Now, when you pay on the 20th, the new agreement is 20th, accord and satisfaction. So that's now the new agreement of 20th, meaning you have removed the one of 18th to now the one of 20th. There are many cases in there. Look at discharge by breach. And look at the fundamental. What was the heart of the contract? Was the heart of the contract breached? In the case the heart of the contract is breached, then definitely you will have to rescind of that contract. And then from there we go to illegality. Illegality, I urge you to read Ben's book, Illegality, all those contracts which are illegal, contracts of fraud, chimpati contracts, contracts of maintenance, contracts to defraud revenue, contracts to promote sexual immorality, contracts in restraint of trade. Now, colleagues, contracts in restraint of trade, this one is very important. That when you're working for somebody and you leave their job, they can restrain you not to do the same job. Like this, for example, if I work with Coca-Cola, then they say, because you've been working with us and you're leaving our company, you sign a contract that said that you will not either do the same business for a period of time, or you won't carry out business in that same area. But again, there are exceptions. If I go very far away, they are in Mukono, I go to Kapchora, and that is okay. They cannot restrain me from Kapchora because I am not encroaching on their mercantile, or on their market, on their customers. You understand? So that's what we mean by restraint in trade. All those are illegal contracts. So discuss them, read Ben's book in terms of illegality. Then we have the concepts of duress and undue influence. Then please look at it. What do we mean by duress? What was the position of the common law in terms of duress? And then undue influence is more on fiduciary relationship. You look at all those fiduciary relationship, lawyer, client, and others. Then the other topic in under contract law, let's go to bailment, indemnity, and guarantee. Colleagues, unless you have appreciated this, I urge you to answer this topic when you really have read and appreciated. But just know the sections of the law, appreciate the Act about bailment, indemnity, and guarantee. You know that bailment is a bailee and a bailer. Who is a bailee? Who is a bailer? Duties of a bailee, duties of a bailer. When can we terminate the bailment and all those areas? What happens if I give you my things, you don't return them on time? So all that, look at it in that way. And then remedies for breach of the contract. You have formed a contract, but there are remedies. So here, look at the types of damages. Why should court award remedies? Court award remedies because they want to put that somebody to the position they were in before the breach of the contract. And then look at the types of damages. We have the nominal damages. These ones are given to the plaintiff since they have not incurred any loss. Look at the case of, okay, let's go to general or special damages. When you incur losses, there are punitive or exemplary damages where they charge you because they don't want it to happen again. Punitive or exemplary damages not to happen again. Then look at the remoteness. Damages need not be remote. There are cases, there are very many cases, Casivanti and others, versus Bexadel and all those other cases. Then look at the areas of assessment of damages, mitigation of losses, liquidation of damages, and all those areas under the remedies. So basically, that's how you will go about with the contract. Contract Law 2. We thank you for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, and like our videos. Until next time, thank you so much. Stay blessed.